Rome Statute of the International Criminal Court, Penalty and Appeal. Part 7. Penalties. Article 77. Applicable penalties. 1. Subject to Article 110, the court may impose one of the following penalties on a person convicted of a crime referred to in Article 5 of the statute. A. Imprisonment for a specified number of years, which may not exceed a maximum of 30 years, or b. A term of life imprisonment when justified by the extreme gravity of the crime and the individual circumstances of the convicted person. 2. In addition to imprisonment, the court may order a. A fine under the criteria provided for in the Rules of Procedure and Evidence. b. A forfeiture of proceeds, property and assets derived directly or indirectly from that crime, without prejudice to the rights of bona fide third parties. Article 78. Determination of the sentence. 1. In determining the sentence, the court shall, in accordance with the Rules of Procedure and Evidence, take into account such factors as the gravity of the crime and the individual circumstances of the convicted person. 2. In imposing a sentence of imprisonment, the court shall deduct the time, if any, previously spent in detention in accordance with an order of the court. The court may deduct any time otherwise spent in detention in connection with conduct underlying the crime. 3. When a person has been convicted of more than one crime, the court shall pronounce a sentence for each crime and a joint sentence specifying the total period of imprisonment. This period shall be no less than the highest individual sentence pronounced and shall not exceed 30 years imprisonment or a sentence of life imprisonment in conformity with Article 77, Paragraph 1, b. Article 79. Trust Fund. 1. A trust fund shall be established by decision of the Assembly of States Parties for the benefit of victims of crimes within the jurisdiction of the court, and of the families of such victims. 2. The court may order money and other property collected through fines or forfeiture to be transferred, by order of the court, to the trust fund. 3. The trust fund shall be managed according to criteria to be determined by the Assembly of States Parties. Article 80. Non-prejudice to national application of penalties and national laws. Nothing in this part affects the application by states of penalties prescribed by their national law, nor the law of states which do not provide for penalties prescribed in this part. Part 8. Appeal and revision. Article 81. Appeal against decision of acquittal or conviction or against sentence. 1. A decision under Article 74 may be appealed in accordance with the Rules of Procedure and Evidence as follows. A. The prosecutor may make an appeal on any of the following grounds. I. Procedural error. 2. Error of fact, or 3. Error of law. B. The convicted person, or the prosecutor on that person's behalf, may make an appeal on any of the following grounds. I. Procedural error. 2. Error of fact. 3. Error of law, or 4. Any other ground that affects the fairness or reliability of the proceedings or decision. 2. A sentence may be appealed, in accordance with the Rules of Procedure and Evidence, by the prosecutor or the convicted person on the ground of disproportion between the crime and the sentence. B. If on an appeal against sentence, the court considers that there are grounds on which the conviction might be set aside, wholly or in part, it may invite the prosecutor and the convicted person to submit grounds under Article 81, Paragraph 1, A, or B, and may render a decision on conviction in accordance with Article 83, C. The same procedure applies when the court, on an appeal against conviction only, considers that there are grounds to reduce the sentence under Paragraph 2, A. 3a. Unless the trial chamber orders otherwise, a convicted person shall remain in custody pending an appeal. b. When a convicted person's time in custody exceeds the sentence of imprisonment imposed, that person shall be released, except that if the prosecutor is also appealing, the release may be subject to the conditions under subparagraph C, below. C. In case of an acquittal, the accused shall be released immediately, subject to the following. I. Under exceptional circumstances, and having regard, inter alia, to the concrete risk of flight, the seriousness of the offense charged and the probability of success on appeal, the trial chamber, at the request of the prosecutor, may maintain the detention of the person pending appeal. 2. A decision by the trial chamber under subparagraph C, I, may be appealed in accordance with the rules of procedure and evidence. 4. Subject to the provisions of paragraph 3, A, and B, execution of the decision or sentence shall be suspended during the period allowed for appeal and for the duration of the appeal proceedings. Article 82. Appeal against other decisions. 1. Either party may appeal any of the following decisions in accordance with the rules of procedure and evidence. A. A decision with respect to jurisdiction or admissibility. B. A decision granting or denying release of the person being investigated or prosecuted. C. A decision of the pretrial chamber to act on its own initiative under Article 56, Paragraph 3. D. A decision that involves an issue that would significantly affect the fair and expeditious conduct of the proceedings or the outcome of the trial, and for which, in the opinion of the pretrial or trial chamber, an immediate resolution by the appeals chamber may materially advance the proceedings. 2. A decision of the pretrial chamber under Article 57, Paragraph 3, D, may be appealed against by the state concerned or by the prosecutor, with the leave of the pretrial chamber. The appeal shall be heard on an expedited basis. 3. An appeal shall not of itself have suspensive effect unless the appeals chamber so orders, upon request, in accordance with the rules of procedure and evidence. 4. A legal representative of the victims, the convicted person or a bona fide owner of property adversely affected by an order under Article 75 may appeal against the order for reparations, as provided in the rules of procedure and evidence. Article 83. Proceedings on appeal. 1. For the purposes of proceedings under Article 81 and this article, the appeals chamber shall have all the powers of the trial chamber. 2. If the appeals chamber finds that the proceedings appealed from were unfair in a way that affected the reliability of the decision or sentence, or that the decision or sentence appealed from was materially affected by error of fact or law or procedural error, it may a. Reverse or amend the decision or sentence, or b. Order a new trial, before a different trial chamber. For these purposes, the appeals chamber may remand a factual issue to the original trial chamber for it to determine the issue and to report back accordingly, or may itself call evidence to determine the issue. When the decision or sentence has been appealed only by the person convicted, or the prosecutor on that person's behalf, it cannot be amended to his or her detriment. 3. If in an appeal against sentence the appeals chamber finds that the sentence is disproportionate to the crime, it may vary the sentence in accordance with Part 7. 4. The judgment of the appeals chamber shall be taken by a majority of the judges, and shall be delivered in open court. The judgment shall state the reasons on which it is based. When there is no unanimity, the judgment of the appeals chamber shall contain the views of the majority and the minority, but a judge may deliver a separate or dissenting opinion on a question of law. 5. The appeals chamber may deliver its judgment in the absence of the person acquitted or convicted. Article 84. Revision of conviction or sentence. 1. The convicted person or, after death, spouses, children, parents or one person alive at the time of the accused death who has been given express written instructions from the accused to bring such a claim, or the prosecutor on the person's behalf, may apply to the appeals chamber to revise the final judgment of conviction or sentence on the grounds that a. New evidence has been discovered that I. Was not available at the time of trial, and such unavailability was not wholly or partially attributable to the party making application, and 2. Is sufficiently important that had it been proved at trial it would have been likely to have resulted in a different verdict. b. It has been newly discovered that decisive evidence, taken into account at trial and upon which the conviction depends, was false, forged or falsified. c. One or more of the judges who participated in conviction or confirmation of the charges has committed, in that case, an act of serious misconduct or serious breach of duty of sufficient gravity to justify the removal of that judge or those judges from office under Article 46. 2. The appeals chamber shall reject the application if it considers it to be unfounded. If it determines that the application is meritorious, it may, as appropriate, a. Reconvene the original trial chamber, b. Constitute a new trial chamber, or c. Retain jurisdiction over the matter, with a view to, after hearing the parties in the manner set forth in the rules of procedure and evidence, arriving at a determination on whether the judgment should be revised. Article 85. Compensation to an arrested or convicted person. 1. Anyone who has been the victim of unlawful arrest or detention shall have an enforceable right to compensation. 2. When a person has by a final decision been convicted of a criminal offense, and when subsequently his or her conviction has been reversed on the ground that a new or newly discovered fact shows conclusively that there has been a miscarriage of justice, the person who has suffered punishment as a result of such conviction shall be compensated according to law, unless it is proved that the non-disclosure of the unknown fact in time is wholly or partly attributable to him or her. 3. In exceptional circumstances, where the court finds conclusive facts showing that there has been a grave and manifest miscarriage of justice, it may in its discretion award compensation, according to the criteria provided in the rules of procedure and evidence, to a person who has been released from detention following a final decision of acquittal or a termination of the proceedings for that reason.